Hello everyone and welcome to Courts Today by LiveLaw. I'm your host Debojeet, here to bring you the day's top legal headlines from across the country. So let's get started. We start at the top as usual as the stage is set for a high-stakes constitutional showdown in the Supreme Court as it prepares to hear challenges to the controversial Chief Election Commissioner and Other Election Commissioners Act of 2023. The heart of the matter is the composition of the selection panel. In March 2023, the Supreme Court, in its landmark Anup Baranwal judgment, mandated that election commissioners be appointed by a panel including the Prime Minister, the Leader of the Opposition, and the Chief Justice of India. However, the new 2023 Act, passed just months later, removed the Chief Justice of India from this panel. The Act replaced the Chief Justice of India with a Union Cabinet Minister, creating a committee that petitioners argue makes the appointment process entirely vulnerable to the executive influence. Despite attempts by petitioners to urgently list the matter before recent appointments were made, the case, which challenges the constitutionality of the new selection body, has been repeatedly delayed. But now a bench will finally hear the pleas on November 11th, raising questions about the independence of the Election Commission of India. Next, we saw today the two biggest names in Indian business get busy at the Supreme Court, all thanks to the epic long-running Sahara-SEBI refund case. The court is now considering a crucial proposal from the Sahara Group to sell a portfolio of 88 properties, including the massive Ambi Valley Resort, to Adani Properties Private Limited. This high-stakes deal is meant to finally address the massive amount of money owed to investors, with SEBI maintaining that over 9,000 crore rupees is still outstanding from the original 2012 Supreme Court order. Sahara, represented by senior advocate Kapil Sibal, claims the sale to Adani could fetch over 12,000 crore rupees. The Supreme Court bench, headed by Chief Justice of India B.R. Gavai, has sought immediate responses from the Union Government and SEBI. To manage the complex claims on the assets, the court has appointed amicus Shekhar Nafade to categorize the properties before any deal can proceed. The matter returns on November 17th. Moving on, we saw the ongoing clash between corporate profits and public health that has escalated to the Supreme Court, as the Swiss pharmaceutical behemoth Hoffmann La-Roche seeks to overturn a Delhi High Court order that greenlit Natco Pharma to manufacture a generic version of the life-saving drug Risdiplam. Risdiplam is a vital treatment for spinal muscular atrophy, and Roche is fighting to protect its patent monopoly, which it asserts is valid until 2035. However, Natco successfully leveraged the statutory defense under Section 107, subsection 1 of the Patents Act 1970, arguing the patent was invalid, specifically under Section 64, subsection 1, clause F, for being obvious and non-inventive. The Delhi High Court sided with the public interest, refusing the injunction and thus upholding the availability of an affordable generic option. Roche's appeal to the Supreme Court now represents a final aggressive push to reverse this pro-generic ruling and re-establish its costly monopoly. Moving on to the Bombay High Court, that has denied anticipatory bail to individuals accused in a major case involving adulterated petroleum products. Justice Amit Borkar was hearing the bail application of Ram Gangwani and Yash Ram Gangwani, whose case stemmed from the seizure of 8 tankers from a customs bonded warehouse, all found to contain adulterated diesel. The prosecution argued the operation was a deliberate camouflage. The illegal sales were routed through 3 different companies, all of which were linked to a single email ID belonging to the one of the accused. The court rejected the defense that this was a private dispute, emphasizing the severity of the offense. Justice Borkar observed that illegality in handling petroleum products directly impacts public safety, on the economy of the nation, and on the lawful revenue of the state. The court concluded that the applicants' use of paper transactions to conceal their true activities raised grave suspicion, making them ineligible for the extraordinary relief of anticipatory bail. Taking note of the Punjab and Haryana High Court, that has issued a scathing indictment of the state of Punjab's government school system, flagging the sorry state of affairs in its educational institutions. The observations came from Justice N.S. Shekhawat, who was dealing with the plight of the government middle school in Amritsar's Tapiala village. The details were shocking. The school operates without a headmaster or any other staff member, forcing just one teacher to handle all the subjects for all students. Furthermore, the infrastructure is abysmal, with only one room available for 3 separate classes, that is 6th to 8th, and no separate toilet for the staff. The judge forcefully stated that this neglect violates the Right to Education or the RTE Act. Citing Section 7 of the Act, the court held that both the centre and state governments have a concurrent responsibility to provide funds and ensure infrastructure. The court strongly implied that the only reason the mere 9 students attend is likely to receive the midday meal, not quality education. The court has since ordered the Secretary of Education to file a comprehensive report on the condition of all government middle schools in the state, converting the matter into a public interest litigation. In another noteworthy case, the Madhya Pradesh High Court, while denying the permission to terminate a 9-month pregnancy of a rape survivor, noting that the fetus is in a live condition and would endanger the life of the survivor. The case involved a survivor who was a minor aged 15 years at the time of the sexual assault. Justice Vishal Mishra noted that since the fetus was nearly full term and in a live condition, termination was impermissible and posed a danger to the survivor's life. Crucially, the court relied on the Supreme Court's judgment in A Mother of X versus State of Maharashtra, which holds that the consent and reproductive autonomy of the pregnant person is paramount. Since the survivor and her father stated they wished to continue the pregnancy but did not wish to keep the child, the court honored their decision. Consequently, the court directed the Child Welfare Committee or CWC of Satna to take custody of the newborn child 15 days after birth, ensuring the baby is either adopted or handed over to the state government for proper care. In an alarming story coming up, we take a look at the failure of the Telangana state government to address the severe groundwater fluoride contamination, despite being notified about it 10 months ago, has led to a harsh rebuke from the National Human Rights Commission. This apparent abdication of a duty is deeply frustrating for its citizens. This underlying crisis is grave. The groundwater in several Telangana districts harbors fluoride concentrations that vastly exceed safe limits set by both the Bureau of Indian Standards and the World Health Organization. This contamination is not a minor issue. It directly poses serious public health risks, including severe skeletal fluorosis that can lead to physical deformities, kidney damage, and even crippling paralysis. The NHRC asserted that the state's inaction directly breaches citizens' constitutional right to health and safe drinking water guaranteed under Article 21, that is, right to life. After issuing an initial notice in June and a reminder in August, the Chief Secretary's office provided no compliance report. In a thoroughly exasperated final warning, the NHRC declared that this continued inaction will be viewed seriously, holding the Chief Secretary personally responsible for non-compliance. A final 4-week deadline has been set, after which the Commission will initiate appropriate action under the Protection of Human Rights Act of 1993. It appears that for the state, public health emergencies are only emergencies if officially acknowledged. And finally, today the long-running legal battle between cricketing legend MS Dhoni and retired IPS officer G. Sampath Kumar took a new turn in the Madras High Court, with the court reserving its order on a crucial appeal. The dispute originated back in 2014 when Dhoni filed a massive 100 crore defamation suit against Kumar, along with Z Media and others. The suit alleged that they made false and defamatory statements that tried to drag Dhoni's name into the infamous 2013 IPL betting and fixing scandal. Sampath Kumar, who investigated the betting scandal, appealed to the High Court to reject Dhoni's entire suit, arguing he was merely performing his duty and had been exonerated in departmental proceedings. However, the single judge in 2021 had refused to reject the plaint, stating that Kumar's defense must be tested during a full trial. Now, a division bench has heard Kumar's appeal against that 2021 refusal and reserved its verdict, keeping the decade-old high-profile case hanging in the balance. And that's a wrap on courts today. It was a busy Tuesday for the courts as usual, and remember, to access a more detailed coverage of every story mentioned today, visit www.livelaw.in. This is Debojeet Das. Thank you for watching.